When it comes to issues at work, understanding your rights is vital.
When we're dealing with employment law cases at the McKinstry Company, we're often asked, are we able to act for employees or only employers? And at the McKinstry Company, as with many other law firms, we can act for both parties, we can act for both sides, albeit not at the same time. The time at which you might want to consult a solicitor in relation to an employment issue will really depend on the issues that you're experiencing. Some people have to consult us whilst they're still at work, whilst they've got an ongoing issue in an employment situation. For others, it might be when the employment has come to an end if they have been dismissed or they have decided to dismiss an employee. If you're going to instruct a solicitor to deal with an employment law case on your behalf, it's very important that you instruct a solicitor at an early stage. There are strict time limits that apply in getting any cases before the Employment Tribunal, in particular if you're an employee. Ordinarily, that time limit is one of 3 months from the date of the event occurring. That might be 3 months from the date of dismissal, for instance. If you instruct us to pursue an employment case on your behalf, or if you're an employer wishing representation in defending any claim, then we can offer a variety of funding options. For employees, we offer the availability of legal aid. There is often the facility within a household insurance policy to instruct your own solicitors, or alternatively, we can deal with that on a private basis. Similarly, for employers, often there is a directors and officers policy that might apply which will provide insurance cover, or alternatively, the private funding option is available. The difference with employment cases as opposed to those cases that are raised through the courts is that ordinarily, if you win your case, whether you're employee or employer, you won't recover costs from the person on the other side. What you might recover is some form of contribution towards any fees that you've had to pay to the Employment Tribunal, but otherwise this is something that has to be factored into the decision to pursue or defend the claim in the first instance. In the event that you are pursuing or defending a claim which is in the Employment Tribunal, then ordinarily you wouldn't expect to appear. I say that because the vast majority of the cases resolve. They either resolve through the intervention of ACAS or alternatively in steps that we take to bring the case to a successful conclusion.
Celebrating 30 years, the McKinstry Company, a law firm for life.